If you are watching this video right now, there is a very good chance that what I am about to share with you could dramatically change your life, the lives of your family members, or someone you deeply care about. February 2026 is approaching faster than most people realize, and the immigration landscape in the United States is about to undergo some of the most significant transformations we have seen in decades. I am not saying this to alarm you unnecessarily, but I am saying this because you deserve to know exactly what is coming so you can prepare yourself and protect your future. Before we dive into everything you need to know, I want you to do me a quick favor. If you find this information helpful at any point during this video, please hit that subscribe button and turn on the notification bell. We release updates on government benefits, immigration changes, and financial news that affects everyday Americans every single week, and I do not want you to miss a single update that could impact your wallet or your status in this country. Now let me get straight to the point. The immigration system in the United States has been under intense scrutiny for years, and the changes that are scheduled to take effect starting in February 2026 represent a fundamental shift in how the government handles everything from visa applications to green card renewals to naturalization processes. Whether you are a lawful permanent resident, someone on a work visa, a family member sponsoring a relative, or even a naturalized citizen who still has family members going through the immigration process, these changes could directly affect you in ways you might not expect. Let me start with what we know for certain. The Department of Homeland Security has been working on a comprehensive overhaul of immigration processing procedures, and several of these changes are set to be fully implemented by February 2026. One of the most significant changes involves the way background checks and security screenings are conducted. Starting next year, the government will be using enhanced biometric verification systems that go far beyond what we have seen in the past. This means longer processing times for many applications, but it also means that anyone with even minor discrepancies in their records could face extended delays or additional scrutiny. If you have ever had any issues with your immigration paperwork in the past, even something as simple as a typographical error on a previous application, now is the time to get those records reviewed and corrected. I cannot stress this enough. Many people assume that small errors from years ago will not come back to haunt them, but under the new verification systems, these discrepancies will be flagged automatically, and resolving them after the fact will be much more difficult and time-consuming than addressing them proactively right now. Another major change that will affect millions of people involves the public charge rule. For those of you who are not familiar with this term, the public charge rule is essentially a test that immigration officials use to determine whether someone applying for a green card or certain visas is likely to become dependent on government assistance. The interpretation and enforcement of this rule has changed multiple times over the past several years, but the February 2026 guidelines represent the most comprehensive version we have seen yet. Under the new framework, immigration officials will be looking more closely at an applicant's use of certain federal benefits, including some programs that were previously not considered under public charge determinations. This is particularly concerning for seniors and their families because many older immigrants rely on programs like Medicaid, Supplemental Nutrition Assistance Program benefits, or housing assistance to make ends meet. If you or a family member are in the process of adjusting status or applying for naturalization, understanding exactly how your benefits usage might be evaluated is absolutely critical. I want to be very clear about something here. Using benefits that you are legally entitled to receive is not automatically disqualifying, but the way these benefits are weighed in the overall determination process is changing. The new guidelines place more emphasis on self-sufficiency and require applicants to demonstrate a stronger track record of financial independence. This could mean providing additional documentation, securing affidavits of support from sponsors with higher income thresholds, or in some cases, making difficult decisions about which benefits to continue receiving during the application process. Now let me talk about something that affects a huge number of families across this country, and that is family-based immigration sponsorship. The February 2026 changes include new requirements for United States citizens and lawful permanent residents who are sponsoring family members for immigration benefits. The financial responsibility thresholds are being adjusted, and sponsors will need to demonstrate higher income levels or assets to successfully bring family members to this country. For many seniors who are living on fixed incomes, this creates a challenging situation. If you are retired and receiving Social Security benefits as your primary source of income, you may find that your income alone does not meet the new sponsorship requirements. This does not mean sponsoring a family member is impossible, but it does mean you may need to find a joint sponsor with higher income or explore other options to meet the financial requirements. The processing times for family-based petitions are also expected to increase significantly. The backlog of cases has been growing for years, and the new security screening procedures I mentioned earlier will add additional time to an already lengthy process. If you have been thinking about filing a petition for a family member, waiting could cost you months or even years of additional delay. The applications filed before February 2026 will be processed under the current guidelines, which in many cases are more favorable than what is coming. Let me shift gears and talk about naturalization, because this is an area where many people are unaware of the changes that are coming. The citizenship test and interview process is being updated, and the new requirements will be more rigorous than what applicants have faced in the past. The civics test is being expanded to include additional questions, and applicants will be expected to demonstrate a higher level of English language proficiency. For seniors, there have always been certain accommodations available. Applicants over a certain age who have been lawful permanent residents for a specified number of years can take the civics test in their native language or may be given a simplified version of the test. These accommodations are not being eliminated entirely, but the eligibility requirements are being tightened. If you are approaching the age threshold for these accommodations, applying for naturalization before February 2026 could mean the difference between qualifying for an easier test and facing the full standard examination. I also need to address something that affects lawful permanent residents who travel internationally. The rules governing travel outside the United States for green card holders are being clarified and in some ways becoming stricter. Extended absences from the country have always been a potential issue for maintaining permanent resident status, but the new guidelines provide immigration officials with more tools to scrutinize travel patterns and question the intent of green card holders who spend significant time abroad. If you are a lawful permanent resident who regularly travels to visit family in another country or who spends extended periods abroad for any reason, you need to understand exactly what these changes mean for you. There are specific documentation strategies and re-entry permits that can protect your status, but you need to plan ahead. Showing up at the border after an extended trip without proper documentation could result in serious problems that are much harder to resolve under the new framework. For those of you who are on temporary visas, whether that is a work visa, a student visa, or any other non-immigrant category, February 2026 brings changes that you need to be aware of as well. The enforcement of visa terms and conditions is being strengthened, and the consequences for even minor violations are becoming more severe. Overstaying your authorized period of stay, working without proper authorization, or failing to maintain the requirements of your visa category could have permanent consequences for your ability to return to the United States in the future. The new tracking systems being implemented will make it much easier for immigration authorities to identify visa violations in real time. In the past, some violations might have gone unnoticed or been dealt with administratively. Going forward, these violations will be flagged immediately and could trigger removal proceedings or bars on future immigration benefits. I want to take a moment to talk about what all of this means for mixed status families, because this is one of the most sensitive and important topics in immigration today. A mixed status family is one where different family members have different immigration statuses. Perhaps one parent is a naturalized citizen, another is a lawful permanent resident, and children might have various statuses depending on where they were born and when. In some families, there may be members who are undocumented or have temporary protected status. The February 2026 changes create new challenges for these families. The increased information sharing between government agencies means that applying for benefits or services for one family member could potentially trigger scrutiny of other family members. This does not mean you should avoid benefits you are entitled to, but it does mean you should be working with knowledgeable advisors who understand how these systems interact and can help you navigate them safely. Now, I want to give you some practical advice on what you should be doing right now to prepare for these changes. First and foremost, if you have any pending immigration applications, or if you have been thinking about applying for any immigration benefit, do not wait. The applications that are filed before February 2026 will generally be evaluated under current rules, and in many cases, those rules are more favorable than what is coming. Second, gather and organize all of your immigration documents. This includes every approval notice, every travel stamp, every employment authorization document, and every piece of correspondence you have ever received from immigration authorities. Under the new verification systems, you may be asked to provide documentation going back many years, and being able to produce these documents quickly could make a significant difference in how your case is handled. Third, if you are using government benefits of any kind, understand exactly how those benefits might affect your immigration case. Consult with an immigration attorney or a qualified representative from a nonprofit organization that provides immigration services. Do not rely on advice from friends or family members who went through the process years ago, because the rules have changed and will change again in February. Fourth, be very careful about your travel plans. If you are a lawful permanent resident planning an extended trip abroad, consider whether that trip could be delayed until after you have consulted with an immigration professional about protecting your status. If you must travel, make sure you have all necessary documentation and understand exactly how long you can be away without jeopardizing your residency. Fifth, if you are eligible for naturalization, seriously consider whether applying now makes sense for your situation. Becoming a United States citizen provides protections and benefits that are not available to lawful permanent residents, including the ability to travel freely without worrying about re-entry issues and protection from deportation. The naturalization process takes time, so starting now means you could potentially complete the process before the new rules take effect. I know this is a lot of information to take in, and I know it might feel overwhelming, but here is what I want you to remember. The immigration system, for all its complexity and challenges, is still navigable. People successfully go through this process every single day. The key is being informed, being prepared, and taking action at the right time. The worst thing you can do is ignore these changes and hope they do not affect you. The best thing you can do is educate yourself, seek qualified help when you need it, and make proactive decisions about your future and the future of your family. Before I wrap up this video, I want to remind you that immigration law is extremely complex and individual circumstances vary widely. Nothing in this video should be taken as legal advice for your specific situation. If you are facing immigration issues or have questions about how these changes might affect you personally, please consult with a qualified immigration attorney or accredited representative who can evaluate your unique circumstances and provide guidance tailored to your needs. I also want to hear from you in the comments below. Are you concerned about these February 2026 changes? Are you in the middle of an immigration process right now? What questions do you have that I might be able to address in future videos? Your feedback helps me understand what information you need most, and I read every single comment. If you found this video helpful, please give it a thumbs up and share it with anyone you know who might be affected by these changes. Immigration affects millions of families across this country, and getting accurate information out there is more important than ever. Thank you so much for watching. Make sure you subscribe to this channel so you do not miss any updates on immigration changes, government benefits, and other important news that affects your life and your family. I will see you in the next video, and until then, take care of yourself and stay informed.